Hello, everybody. My name is Cassandra Janicki, and I am your instructor for business law, BUSAD18 at Columbia College. Today, we're going to be talking about we're going to start talking about the last large leg of our class, which is really giving you an overview of the different types of business organizations, how they are formed, what obligations occur for the individuals who are engaged in those organizations over the life of the business, and then what happens in the ultimate breakup, so to speak, of each of these different types of organizations. So today we're going to be talking about kind of the most basic ones, which are our partnerships. Chapter 39 in your book starts talking to you about general partnerships, and then chapter 40 dives a little bit deeper into the types of partnerships that are able to limit the personal liability of the individuals engaged in the business organization. So let's get started. So when we look at the nature and creation of partnerships, there's a very easy definition for us to discuss, and that is that a partnership is a relationship that is created by the voluntary, again, very important piece of this, voluntary association of two or more people to carry on as co-owners of a business for profit. Partners are general agents for the partnership. So when we think back to the conversation that we had about agency, they are the most broad form of agent that a business organization can have, and they do not act as employees for the partnership. The characteristics of a partnership that differ from maybe other types of business organizations or that are specific to partnerships include the fact that a partnership is voluntary and consensual. It involves partner contributions of capital, so money, services, the sweat equity, if you will, or a combination of both. Partners or co-owners that are engaging to transact the business of the firm for profit. And where profit is not the objective, then the individuals who are engaged in that entity are working under what is typically called an unincorporated association. So the biggest, most important thing that you will have in a partnership is going to be your partnership agreement. Now, when we hearken all the way back so long ago, when we talked about contracts, what is the first thing really, that everybody wants to start talking about but isn't sure how to get there? Does a contract have to be in writing, or can a contract be enforceable if it's oral? You and I both know that a contract that is oral only, spoken only, can be enforceable. But the problem is that you leave so much up for the interpretation of others later on if you do not have a discrete and concrete evidence of that agreement, right? So this is one of those times, Cassandra Janicki's rule of thumb number one, if you're going to enter into a partnership or any business organization, put it in writing. It should always be in writing. Why? Because when you're 10, 20, 30 years down the road and you're having to have a court evaluate whether or not you have sufficiently done something in relation to your partnership, whether or not you've acted in good faith, whether or not you've acted consistent with the partnership agreement, it will be so important to have a written document that you look over every once in a while, amend when you need to, just to ensure that everybody is operating on the same even playing field when it comes to your partnership. So these, as I said, should be in writing, mitigate those misunderstandings, should be a formal document that is titled, right, termed the partnership agreement, or you can also call it an articles of partnership, articles of co-partnership. It's just really important to be clear. Now, you're taking my class and you will learn that these, rules are important, right? So we're going to do what? We're going to put it in writing. But what happens for those folks who don't take this class or who haven't taken a business law class who don't put it in writing, right? So the questions we then have to ask ourselves is, how do you determine if a partnership existed? So, as I said earlier, you can operate a partnership even if you didn't actually intend to, right? So it's kind of one of those situations where there is an implied partnership. So you can create a partnership by accident, even if you don't label it as such. I apologize. Where the parties have agreed to operate for profit as co-owners, even if they don't call it a partnership agreement, it's a partnership agreement. So some factors that courts will look at to determine whether or not a partnership existed. They're going to look at who controls what within the organization. The presence or absence of control will be a very significant determining factor about whether or not a partnership existed and whether a particular person is a partner. This type of evaluation will also be important if you have individuals who are claiming to be partners, maybe de facto partners who weren't named in the original agreement, but they have been acting or exercising partnership control. Where individuals share both profit and losses, that will be a strong evidence that a partnership existed and that the individuals engaged in the sharing are in fact partners. But contrarily, the sharing of profits but not of losses is not strong evidence of, sharing profits but not losses can also be evidence of a partnership, but it is less so, because typically in a general partnership, absent something contrary in the agreement itself, the sharing of profits, the sharing of losses, those things are going to be the same for each partner. Again, unless your partnership agreement says otherwise. Sharing of gross returns, it's not good evidence of a partnership existing. Contribution of skill and labor. So you can be a partner in a partnership even if you don't put forth capital. You can put forward sweat equity, and that courts have found pretty consistently is sufficient evidence to show that you are a partner within a partnership. If an individual who is providing a service for a fee, and that fee is a regular fixed payment, regardless of whether it comes out of a profit, regardless of whether it's affected by losses, that does not provide adequate proof of partnership for the person receiving that payment. Now, so non-partners can be held liable for issues related to the business organization, the partnership itself, as if they were partners. If third parties are led to believe that the non-partners are partners and they rely on that belief. So a good example of that can be instances where two or more individuals own a business and they utilize a manager for day-to-day operations of that business. The manager engages in partner-like activities, including contracting for the business, including engaging customers, clients, bringing on business, eliminating business, things of that nature. And let's say, for example, a third party relied on their perception of the implied partnership, the implied partner nature of the manager. If they relied on that to their detriment, then that person, even though they're not a partner, may be held liable for, let's say, a breach of that contract by the owners, where that third party relied on that person, the manager in that case, in making their decision to contract with the business in the first place. So it can be really, really important that you, as maybe a non-partner engaging in partnership-like or partner-like activities for the partnership, it may be really important for you to make note to any third party. And in fact, I would recommend you doing that, hey, listen, I know you and I are engaging in negotiations. I know you and I are signing contracts, but I just need you to understand that I am acting as an agent for the partnership. And I would make sure that your nature as an agent is, mentioned on your is mentioned on, whatever documents you sign, maybe even on your business cards, the plaque that you have in front of your desk, all very important so that third parties are on notice that while they're contracting with you, you are contracting on behalf of the partnership. Sorry, my whole brain just lapsed on me. I apologize. So third parties can also hold the purported partnership liable, even if a partnership wasn't purposefully in existence, right? And a partnership can limit their potential liability with a publicly recorded statement of partnership authority. So for example, if you have, 3, 4, 5 partners engaged in a business for profit, but you limit what each and every one of them is allowed to do, able to do, you can file a publicly recorded statement. You can put it on your website. You can put it on people's business cards that are engaged in partnership activities. Just again, so that you're putting third parties on notice as much as you can that, like, hey, if you contract with somebody within that partnership and that partner is exceeding the scope of their agency for that partnership, the whole partnership will not be held liable. Now, partnerships, much like any business organization, are legal entities that can own property, right? So I think oftentimes think of, businesses as entities and not necessarily as, maybe fictional entities is the better way to put it. And even if they are fictional entities, just because they are fictional in nature, right, they aren't a person, they do have a legal personhood, thanks to Citizens United, which gave corporations at least the same rights that you and I have as individual people. And so because of that, partnerships can own property, partnerships can engage in contract relationships, things of that nature. Now, as with any relationship, right, because a partnership is just a legal relationship between individuals engaged in a business for profit, you have to start talking about how do you divide up stuff, right? Like, what does that look like? And so when we look at tenancy and partnership. So when we think of tenancy, I think people think like, oh, I am a tenant in an apartment building. Oh, I am a tenant renting a room in a home, right? So there's this relationship that you have with another entity that allows you to have ownership or the right to exclusive use of a particular piece of property. So tenancy and partnership is a similar concept, but just not for a house. It's in the partnership itself, and it's in what does the partnership own? So absent an agreement to the contrary within your partnership agreement, each partner is going to have equal right to property for partnership purposes. So they're going to be able to use the partnership's vehicle for partnership business. They're going to be able to use the partnership's equipment for partnership purposes, right? There is no divisible interest within partnership property for each individual partner. What does that mean? Well, what that means is that, let's say a partner goes bankrupt, and because they're in a general partnership, there is no limited liability. So bankruptcy can go after their personal assets and their partnership assets. They don't get to go after or try to bring into the bankruptcy estate a particular piece of property. They just do a valuation of the entirety of the partnership's property. And then the portion that is attributable to the partner that's going bankrupt, that's the amount that they would take out of the business. Now, a good thing about general partnerships is that if an individual partner dies, and we'll talk a little bit later about other ways that a partnership can get dissolved or reasons why, but upon death, the interest in partnership property goes to the surviving partners. It doesn't get to go to a spouse. It doesn't get to go to their family, those types of things that it's not deedable, if you will, or leavable, if you will, in a will. So that interest is going to go to the remaining partners so that they could so that they can continue operations of the partnership. Now, when we think of that partnership piece, that last piece that just popped up on the screen, is what becomes the, how does one put this? Can become the stressor. Okay. If an individual no longer wants to be a partner, we'll talk about dissolution in a minute, but it basically means that the partnership goes away unless they can assign the partner's interest to someone else. So a partner may say, you know what, I'll keep engaging in this business, but I want all of my profit to go to my daughter X, or I want it to go to this particular place, right? We talked about assignments when we talked about contracts, that last little bit when we talked about contracts, third-party contracts. The assignee will not become a partner without the consent of other partners. And you may ask yourself, well, why is that, Cassandra? If they get to, get all the profit, or they get to participate as an assignee, they do not become a partner, because much like your willingness to give credit, or a bank's willingness to give credit, right? We are making a best guess based on the individuals that we are partnering with. And so just because one partner wants out or wants to change the agreement doesn't mean that the other partners have to accept that. So when we think about the authority of partners generally, I mentioned to you earlier, right? They act as general agents, so they can do just about anything for the partnership that they need to. Typically, if you have more than two partners, the authority of the partners is ruled by a majority. So let's say you have 5 partners engaged in a partnership. 3 out of 2 on any vote related to the partnership, that's going to rule the day. As I mentioned, some partners can have authority for certain acts. So for example, you may designate somebody as the operations officer, as the executive officer, as the financial officer. Those individuals are going to have an express area of authority. So in that particular area, they will be express agents, right? Typically, co-owners, partners who are co-owners have certain powers. And those powers are limitable or able to be limited through that agreement, that partnership agreement. If a partner, contrary to the partnership agreement, executes a contract on behalf of the business and a third on behalf of the business that exceeded their authority, and the third party was unaware of the limitation, even though that partner acted outside of their scope of authority for the partnership is still bound. The partnership is still in contract. And so it's really important, much like who you choose to have children with and who you choose to get married to, very important for you to also have a pretty high scale of requirements for anybody you choose to engage in partnership activities with. Some things that partners are absolutely prohibited from doing, just based on case law and how we understand partnerships to operate. A partner cannot bind the partnership in a contract that will make it impossible for them to continue business. So any action by a partner that would necessarily cause the cessation of the business will not be bound by that. A partner does not have a suretyship authority. So they do not get to act as surety for the business or utilize the business as a surety. And then lastly, but not leastly, when we talk about prohibited transactions, it will also include the fact that unless the other partners have authorized a particular controversy, issue at hand, potential liability for litigation, unless all of the partners have said, you know what, let's send this to arbitration. Arbitration is binding. And so if you go to arbitration and the arbiter finds against you, it's binding typically. And so that without other partner approval, a single partner cannot agree to enter into arbitration. Confession of judgment. So all partners have an opportunity to defend the partnership in court. You can't prohibit one partner Maybe they have gone up the deep end. Maybe they are not kind or helpful to the other partners or to the business themselves. You can't prevent them from coming and trying to defend the business. The assignment of creditors and personal obligations. So that all has to do with business obligations, credit, issues that arise from the business borrowing money and then an individual borrowing money. Ultimately, the partner cannot assign property for the benefit of their creditors or the business's creditors without authorization from the other partners, unless the other partners have abandoned the business. Similarly, a partner can't discharge their obligations by like interchanging them. So the duties, rights, and liabilities of partners. So you will have kind of heard some of these before. We talked really about the duties of agents, right, in that agency section that we had. And you're going to see that some of those duties are very similar here. So much like with agency, we have the duty of loyalty and good faith to the partnership. You have a duty of obedience to your partnership, and you have an obligation to refrain from any intentional misconduct while you're transacting firm business. And so that one is an interesting one when we think of individuals who engage in sexual harassment, racial discrimination, things of that, where there's intentional misconduct. If you're doing that on the job for the partners, or on the job, you're working for the partnership on behalf of partnership business, you have an obligation to refrain from doing that. And if you fail to refrain from doing that, i.e. engage in intentional misconduct, then the partnership can actually sue you for that intentional misconduct. Partners have a lot of rights as owners of businesses. I mean, you can see this list here. You'd also probably recognize some of this list from when we talked about, sorry. My mind blinked again. When we talked about agency, and also when we talked about some areas of contracts. And so the rights of partners as owners includes management of the business itself, inspection of the books, sharing of profit, discussions about compensation, distribution of capital if it comes to that, contribution and indemnity, payment of interest, repayment of loans. All of those are rights of partners. And those rights of partners dovetail into what the liability of partners in the partnership can be. So in this section for business organizations, you'll see that we will be discussing the RUPA and ULPA, which are the Uniform Partnership Act and the Reformed Uniform Partnership Act. And those are basically, we've talked about uniformed laws before, but uniformed laws are laws that span industries rather than jurisdictions. And so states will choose to utilize the uniform laws as their own. And so these are good ones to talk about in here because the RUPA and the UPA deal with some of this stuff differently. So for example, when we talk about the nature and extent of a partner's liability, under RUPA, partners are jointly and severally, I hate that word, severally liable for contracts and torts within the scope of business. So even where an individual engages, let's say in an intentional tort, like a battery, an assault, sexual misconduct, even if you're not the partner that engaged in that conduct, under RUPA, you as a partner to the partnership are responsible, and so is the partnership. New partners have limited liability for pre-existing obligations. So let's say, for example, you amend your partnership agreement to add a new member. That new partner is not going to be liable for anything that happened before they came on board, right? And then even where a partner leaves the partnership, they are still liable. Jointly, severally. Jointly and severally means that they are equally or that they are all responsible for the entire amount of the liability and their liability will only be reduced after or in response to one of the other individuals paying their portion of the award. Now, creditor claims. So where a debt is contractual, so you've engaged in a contract that requires something to be paid back, the partnership's assets have to be exhausted before the creditors can reach for a partner's individual assets. That is one of the biggest problems with a general partnership. Where you are engaged in a general partnership, you are just a person. You are a person engaged in a partnership agreement. So you, both as a partner to the business and as a regular person, all of what you own, have, that is all subject to being taken on behalf of the partnership. They have to go through all the partnership property first, but then they get to come after you personally. You'll see in a moment that that is why we developed the concept of limited liability companies, partnerships, limited partnerships. That's where that came from, because it was very scary to engage in a partnership with the fear that all of your personal stuff, personal property, your home, your cars, all of that could be subject to the partnership going wrong, right? Now, dissolution, termination, right? It's the divorce part of being a partner and being engaged in a partnership. So a dissolution basically changes the relationship of the partners, and it can be caused by any partner ceasing to be involved in the business. So if no legal basis to continue the partnership exists, then the dissolution ends the right of the partnership to exist in its current form then. What that does is it reduces the authority of the partners, but not their vested rights. So any existing liabilities that they have pending dissolution are still going to remain, and they're still going to be personally liable for their share of it. Now, a couple of different ways that you can dissolve partnerships, right? So this is kind of similar to when we talked about dissolving contracts or how we get out of contracts, right? So you can dissolve a partnership through the active parties. So you can do it by agreement. They can expel a partner if it's allowed for in their agreement. Where there is an alienation of interest, that means that the partners either refuse or cannot engage in a voluntary sale of the partnership or its property, and the court cannot order an involuntary sale, then where we are left is with an alienation of interest. And so that is another way to dissolve a partnership. And then if a person withdraws from a partnership, now that has to be done consistent with a partnership agreement. And if it's not done consistent with the partnership agreement, then the partner who is withdrawing is going to be liable for any damages that the partnership suffered as a result of their violative withdrawal. Another way to dissolve a partnership is going to be by operation of law. So death of a partner immediately dissolves the partnership. Bankruptcy is going to dissolve the partnership, and it's bankruptcy of the partnership or of the partner. Insolvency, however, where your cash in and cash out, your cash out is higher than your cash in. Insolvency does not dissolve it, but it gets you pretty dang close. And then if for some reason the purpose of the business becomes illegal, that is, if the reason that the partnership existed was to engage in some type of business and the government for some reason made that type of business illegal, then that also dissolves the partnership. The court may also get involved in a dissolution, and that can look like a bunch of different things. If one of the partners goes insane or becomes incapacitated, the court can order a dissolution of the partnership. If there's misconduct or it becomes impractical, those are some other reasons why a court may decree that it is dissolved. Lack of success. If a partnership is engaging in conduct that literally can only continue at a loss, it's no longer a partnership, right? Because a partnership is a set of people getting together to operate a business for profit. If you can't operate for profit, you're done. And then sometimes there may just be circumstances that require it. The concept of equity is one that we talked about, right? It comes from way when our English background, right? Courts of equity. But if it's just the fair thing to do because people can't agree or you can't get anything done, then equitable circumstances is another reason why the court may decree dissolution. Now, you got to give notice, right? We talked about this. Like the entire legal field is, 95% of it is just trying to give notice to people. And so when you dissolve a partnership, you have to give notice to the partners. You should give notice to third parties that you deal with through the partnership. Otherwise, you can public it. You can make public by publishing notice of the dissolution of the partnership. If dissolution of the partnership is caused by an operation of law, however, then third-party notification is not required because the courts see the court decree, which is a public document, as sufficient for third-party notice. Now, of course, it's not just the legal piece, right? It's not just like eliminating the partnership and then everything is hunky-dory, right? You got to wind up. You got to take care of the affairs, right? So all partners have a right to participate in that unless there's a court order to the contrary. And much like a bankruptcy and probably also like a divorce, right? Creditors have first claim on all the partnership assets, and then the individual partners, creditors have a stab at the firm's assets. And then each partner is going to receive refunds on any advances that they gave to the partnership. They're going to get back any capital contributions that they gave to the partnership. And then they're going to divide the remaining assets equally amongst all the partners. You may be shocked, but once we're at the dissolution phase, it is pretty rare for us to get to a point where the partners get something back, but not unheard of. Can be done. And you may ask yourselves, well, Cassandra, what if it's a 3-person partnership and one person just wants out and then the other 2 plan to carry on? Yeah, practically, partnership business continues even after dissolution and winding up. What really is important is that there is this technical dissolution and a termination of the original partnership. And then if a new business continues, you have a new partnership, but what are you going to want to do? You're going to want to put it in writing, because we know that a partnership agreement is our most important document when we're talking about partnerships. So we just spent some time going over the concept of a general partnership. And we start there because besides that and like a solo proprietorship, general partnerships are our most common, perhaps least complicated, but also they are the ones that have the greatest liability for individuals engaged as partners in partnership business. And so you may ask yourself, well, Cassandra, what about this LP stuff, limited liability stuff, LLC? I hear about all this limited liability. You're right. But ask me where it came from, when it started. I bet you would be shocked to learn that the first limited partnership law and entity was created in Wyoming. Sit with that for a second. Wyoming. Cool. 1986. It's stunning to me that is where it happened, but Wyoming, apparently, in case any of you ever want to move and start a business, is incredibly business friendly. And so they started the concept. Their Supreme Court actually finally said, listen, you can limit liability, and here's how you do it. So let's talk about it. So limited partnerships are the limited liability version of the general partnership that we just talked about. So members of a limited partnership, you're going to have one or more limited partner who can only lose up to their capital investment in the partnership. And then you're going to have one or more general partners who will manage the business and who are then, because they're general partners, are personally liable for the firm's debts. Why have the 2 different kinds? Well, we have the 2 different kinds because limited partners are really viewed as the capital injection folks, right? These are the people who are putting money into the business for it to flourish. They only want to participate by contributing funds and then receiving back profits. And that is the extent to which they want their potential liability to be limited. Your general partners are going to be those who manage the business. So they're the day-to-day folks. And then they, because they're general partners and maybe do not have to contribute capital, they're the ones who are going to be personally liable for the firm's debts. In order to form a limited partnership, though, it's all about that notice piece, right? And so you have to execute and file a certificate of limited partnership. If you fail to do that, then you are all general partners in a regular partnership, and then that's going to suck. So don't do that. You're going to file it with your Secretary of State, and you're going to note the limited liability nature of the partnership pretty much everywhere. It's going to be in it's going to be in the partnership's name. It's going to be on folks's business cards, right? You're really putting on notice to everybody that, like, listen, there are some cash cows in here, but there are some non-cash cows in here. And the non-cash cows in here, those are the folks that gave us no money, but put in the work. And so those are the people you get to sue for their houses. Contrarily, the cash cows are the folks that just gave money, don't invest their time. And so you only get up to what they invested. Now, the limited partnership agreement, you still have a partnership agreement. You just happen to note the limited liability nature of the limited partners who are engaged in the partnership. And you note the, sorry, my nose. Whew. Am I going to sneeze? No. And you note the limited nature of the limited liability partners, the general nature of the general partners. And then if there are any ambiguities, we know, right, one of the rules that courts use in interpreting contracts is that they're going to construe any ambiguity in the document to the drafting general partners. So make sure you're having somebody draft a partnership agreement that knows what they're doing. Probably a lawyer. Have a lawyer do it. Now, some characteristics of limited partnerships. So I talked to you earlier about the UPA and the RUPA, right? Uniform Partnership Act, Revised Uniform Partnership Act. I know you're going to be shocked by this, but we also have a uniform set of laws for limited partnerships. So under ULPA and then under RULPA, the ability of limited partners to contribute to the limited partnership is a little different. Under ULPA, which is kind of the old version, right? The OG version of how you formed a limited partnership, you could only contribute cash or property, right? So we're talking about that very typical cash cow investment injecting partner. Under RULPA, they recognize that limited partners should also be able to contribute services, because sometimes those services can be as valuable or more valuable than cash alone. And those people who can contribute services and cash, or even just services, should receive or be able to benefit from the limited liability nature of the partnership. So, as I mentioned, limited partnership must be in like everything, right? You got to give notice to everybody and their brother. Okay. General partners are going to manage the firm, and they're going to be personally responsible for all the debts. We talked about that. If every partner wants to avoid any personal liability, then they can have the option of incorporating. We will talk about incorporating not next time, but the week after, when we start talking about corporate formation. Wait, no, back it up. It is next week. Corporate formation is next week. And that's how you avoid every single person engaged in the business from having personal liability. A big one here, right? So general partners manage, limited partners do not. If a limited partner engages in managerial participation for the firm, they may, but are not required, to lose their limited liability status, right? Because if you think about it, I think the thought process from courts is that general partners are the day in, day out folks. They are the ones who, through the management of the business, have and exercise the greatest amount of control over what the partnership does, over the contracts that they engage in, those types of things, the relationships that they build. And so if you're not engaging in that, if you're not engaging in that type of management of the business, then why should you be held liable for managerial mistakes? Contrarily, though, if you're a limited partner who's actively engaging in management, then you are acting like a general partner, which means that you get to be held accountable to the same standards as a general partner. So if you don't want to be personally liable, my recommendation would be don't manage. Talk about that from personal experience. I joke, but not really. So, a limited partner, this is also unique to limited partnerships, and we'll talk about derivative suits when we talk about corporations as well. But there just isn't a cause for these in general partnerships, so it's unique in that respect. A limited partner can bring a derivative action on behalf of the limited partnership to sue a general partner because they think that the general partner is engaging in conduct on behalf of the business that is inappropriate or is illegal or endangers the limited partner's opportunity for profit, things of that nature. It's a derivative suit. And then harken all the way back to, 10 minutes ago, where we were talking about dissolution of a general partnership. Dissolution happens for limited partnerships in the same way that it does for general partnerships. Now, another form of limited liability business organizations includes the LLC. I feel like everybody has heard LLC somewhere mentioned, right? Some business says, oh, we're an LLC, right? So in order to engage in the creation and operation of a limited liability company or limited liability corporation, some people have heard it that way as well. You have to create a written document of articles of organization. You have to file that with your Secretary of State, and you have to use the words limited liability or LLC somewhere in the name of the business. Similar to LPs, right? It's all about that third-party notice. Promoters are individuals who engage in promotion of a business. So they're seeking investment or they're engaging in contractual relationships on behalf of a company before it exists formally. Promoters are not going to be liable under an LLC and are not going to be liable, and there won't be members of an LLC typically. And then capital contributions can be cash, property, or services. And as I mentioned just now, the owners in an LLC are members of the LLC. It's like the members only club. Some of you are probably too young to know what that's a reference to, but that's fine. So management of an LLC is different from that of an LP and different from that of a GP, right? So it is vested in the members equally via their operating agreement. If the LLC is member managed rather than a manager managed company, then each member has equal rights to manage the LLC. That sounds like a lot of cooks in the kitchen. So I think a appropriate thing to do where it works for your organization is to have a manager managed company rather than a member managed company, because then non-manager members have no management rights. So you are designating who amongst the members, if any, because it could also be an employee, is doing the managing. Fewer cooks in the kitchen. Managers are going to have the same fiduciary duties as corporate officers do to a corporation, meaning that, because we'll talk about that when we get to corporations, but a lot of that same stuff that we talked about in general partnerships, duty of good faith, you have to be putting the organization's best interest forward, like all of those things. Now, some other things that the LLC shares. Distributions of profits and losses are going to be shared according to the operating agreement. So much like the partnership agreement, the operating agreement is super, super, super important. LLC property, again, an LLC is an independent, judicially or legally created entity that owns business and holds property in its own name. Interest in a LLC is assignable, but not the right to participate in management. So if it's a member managed LLC, just because you are assigning your interest in the LLC to somebody else does not mean that they become a manager. Much like that debtor creditor assessment, like I'm looking in your eyes, it's you I'm engaging with, not somebody else. So LLCs are typically dissolved based on state law or federal law, depending on which jurisdiction your organization triggers. And so the LLC may, under certain circumstances, be able to continue existing if there is member consent to allow that. LLCs are classified as partnerships for tax purposes, so there really isn't a tax benefit to an LLC in that you get taxed twice for it, right? The real big bonus for like corporations is the tax shelter that it provides. Some members may be held personally liable in an LLC even beyond their initial capital investment, particularly where those are members who are managing. So something to keep in mind if you don't use a manager managed LLC. A little bit of distinguishment for LLCs. You know, there are a couple of different types of business organizations that we won't delve too deeply in because they're pretty boutique and they have a very small percentage of like the business organizations that exist in the United States. And they're typically very boutique because they're very specific. And so, for example, if you've ever heard of a subchapter S corporation, those are really limited. You can only have 75 members, 75 shareholders. They have to be U.S. citizens or resident aliens. Contrarily, you know, LLCs, you have no limit on the number of members and you have no requirement that they be a certain type of person or have a certain type of legal designation. LLCs and limited partnerships, right? General partnerships and an LP or a GP, they're going to be liable for all their obligations personally and professionally, whereas all LLC members have limited liability. So that's like the bonus of an LLC. You know, we expect that LLCs will replace partnerships. Closed corporations, which are even smaller, those are like 25 people and they have to be familially related. And S corporations, but not publicly traded corporations, because they're really solving two different problems, right? Corporations allow for a different methodology of capital injection and a different method of operation that like an LLC could accommodate, but doesn't necessarily have to exist for that purpose. And so LLCs are just generally easier than subchapter S. They're generally easier and less, you know, liable or less personal liability associated with an LP. So that's kind of why. And then so last one to talk about, I got confused. Limited liability partnerships. So limited liability partnerships will shield innocent partners to eliminate their vicarious liability within partnerships. And so this is really where I think the courts struggle with holding individuals who do not engage in malicious or intentional actions like torts, breaches of contract, things of that nature, and then really struggle conceptually with holding other people accountable beyond their own investment for an individual's personal behaviors. So limited liability partnerships really focus on like particular areas of engagement. So like doctor's offices, optometrists, lawyers, those types of professional career oriented areas will utilize an LLP because it is so, I think, abhorrent to hold one person liable for the actions of another that they can't control, right? It's that concept of malpractice across partners rather than down to people that you supervise. So for example, if you are a lawyer who is a partner at an LLP, and your co-partner engages in malpractice, and so do the 3 employees that work under that person, without your consent, without your knowledge, without your way to control that, you do not get held liable for that person's poor behavior beyond your own initial investment into the LLP itself. So LLPs are limited to certain types of professions, legal, medical, things like that. You are going to note and register an LLP in the same way that you do an LLC or an LP. So you're going to register with the Secretary of State. Firm name has to have LLP or limited liability partnership. So that, ladies and gentlemen, is the end of today's lecture. Stay tuned because we'll be hitting corporations next as our next big business organization to dive into. Have a great day.